some of the complexity and challenges that we've had with the duty of care in North America, and I'll focus specifically on Delaware law, just so you understand conceptually what a difficult concept it is in law and perhaps why. And then I'm going to focus secondly on the challenge and I think the opportunity for the SVS and the Chilean business community looking forward. And I think you stand at a La Polar presents a very interesting challenge and a very interesting opportunity, and I think it's a very important choice that both the regulator and the corporate community will have to make, and it will have consequences for corporate governance, but for wealth creation in this country. Let me start with the some of the complexity of the duty of care and the duty of loyalty, but I'm only going to touch on the duty of loyalty very briefly. To understand them in the context of common law in North America, and again I'll deal with Delaware, you first have to understand that these concepts, these duties, were transplanted from trust law into corporate law. They're phrased in very open-ended contextual terms for a reason. The whole purpose of corporate law in North America was really to internalize relationships within the corporation, essentially by norms and by contract, the articles of the corporation, shareholders' agreements, rather than leave those relationships to be reinvented time and time again in the marketplace. So you can think of the duty of care, I think of the duty of care almost as this incomplete contract between the corporation and its various stakeholders on the one hand, and management and directors on the other hand, saying, here is what we expect of you in the series of relationships. The duty of loyalty, and Armando mentioned the Chispas case, which I had some involvement with when I was living here, is a little bit different, because when it comes to the duty of loyalty, there's almost an acknowledgement that markets aren't efficient. We have to deal with it. It deals with conflicts of interest. So I think it's a much easier set of relationships to govern, but it's not a coincidence that while we've had a duty of care articulated in corporate law in North America for a long time, it was well over a century before the Delaware courts first imposed liability on directors for breach of their duty of care. And up until that point, for over a century, the courts dealt with it by deference to the business judgment of directors. The case, and is always the case, bad facts make bad law. The case in which the Delaware courts first imposed personal liability was a case that I suspect many of you are familiar with, Smith and Van Gorkum. It was clear negligence. It was a case of a transaction, there were conflicts, an acquisition, management buyout, clear conflicts of interest. The board made a decision without the benefit of advice, even from management, without the benefit of even seeing the agreements that were the subject of the decision. And in fact, the chairman of the meeting, who had a conflict of interest, cut the meeting short because the board had to get to the opera that evening. So in the middle of a discussion, the meeting was terminated, a vote was taken, and they went to the Lyric Opera in Chicago. And the court awarded liability damages against the directors, $23 million, which seemed like a lot of money at the time. What happened immediately after that decision? First of all, there was an insurance crisis. Secondly, within 2 years, Delaware corporate law was amended to allow corporations to opt out, to contract out, in effect, in their articles of incorporation, of civil liability for non-intentional breaches of the duty of care. And of course, 90% of Delaware corporations or more immediately put that provision. You had to get shareholder approval in order to amend your articles. That provision has become standard in articles for Delaware corporations. So the effect of Smith and Van Gorkum, rather than raising the standard of care or the duty of care, was in effect to say, and there are always victims in these situations, so the directors of TransUnion, which was the company in that case, faced liability, personal liability, but the immediate consequence was to raise the standard so that the duty of care only applied for intentional breaches. Civil liability only applied to intentional breaches. Even if you don't have that provision in your Articles of Incorporation, the Model Business Corporations Act in the United States, which is the basis on which most states update their corporate law, distinguishes between standards of conduct and standards of liability. So there's a distinction between what's expected of directors and the standard below which liability will be imposed. Liability generally is only imposed if one can prove either bad faith or that directors weren't informed to the extent that they, the directors, believed appropriate in the circumstances. The most recent case is Walt Disney and their civil claims against the directors, again in circumstances where the board made extraordinarily generous compensation arrangements with a CEO who lasted for less than a year, was to deny liability because the plaintiffs couldn't demonstrate that there had been intentional misconduct. So again, back to the Delaware test, you have to demonstrate intentional misconduct. Now, all of this, for me, illustrates sort of the challenge or the difficulties that arise when you divorce the logic of legal concepts from the economic context of the relationships that we're talking about. These standards, as I said, are highly contextual. Courts are challenged to interpret reasonable expectations in very particular facts and circumstances. And the way that in North America we deal with the uncertainty that creates is twofold. One is the very nature of common law. So there are cases literally every month dealing with the duty of care. So we have this rich body of interpretive authority, if you will, where directors know precisely what is expected of them, both in terms of the standard of conduct and the standard by which liability will be imposed on them. Beyond that body of law, we also have a whole range of subsidiary or implementing rules. There are codes, there are treatises, there are model laws. One of the difficulties that you face here in Chile is that you don't yet have that kind of body of interpretive guidance yet in a sufficient degree. Now, Armando pointed to some guidance, but it isn't evolved to the stage that if I were a director in Chile, I would say, I know precisely what is expected of me. That's even in Canada, we never know precisely what's expected, but I can give a board or an individual director advice and be pretty clear about the threshold below which they may attract liability. I would be more challenged to do that in Chile. It's made even more complex, again, in Chile compared to North America, because what we've had is a number of cases where, in effect, administrative law standards have been applied to impose what will eventually likely be civil liability. So the SVS makes a decision, imposes a sanction, and that sanction will become the basis for civil claims. in a country where, again, limited guidance, limited insurance, joint and several liability of the directors, a very lengthy process within the court system for the resolution of these issues, and relatively inexperienced courts, so the risk is, perhaps the likelihood is, that the courts will defer to the expertise of the tribunal. And all of this in spite of extensive corporate governance reform in Chile over the last 10 years. This is just an area that hasn't been sufficiently addressed. Which brings me to looking forward and what I see as both the challenge and the opportunity. The opportunity is for the SVS to be a hero, but it will take a certain amount of courage for reasons that I'll discuss. And it would be a hero by working with the corporate sector, even as the La Polar case works its way through resolution in the courts, to address the uncertainty and the issues that have been raised in the case. And the kinds of issues that come to my mind, one is obviously, the standard for review. Should there be a distinction between fraud and negligence? Should there be a distinction between intentional and unintentional breaches of the duty? The kinds of issues that Armando was talking about in terms of what kinds of internal controls or risk management should be present. Is the nature of the duty, is it a duty to inform as opposed to a right to get information? Is there a special duty for the committee of directors, which leads to some interesting and I think perverse results when you impose higher standards on certain directors than other directors? Are there different degrees of responsibility? Do you assign responsibility, different degrees of responsibility to directors who were on the board for a long time as opposed to directors who only joined the board and only were on the board for one meeting or two meetings before the events that gave rise to the charges arose? Is it time-related liability? Now, all of these kinds of issues are obviously awkward for the SVS to address at the same time that the cases that the Super has brought in La Polar are being resolved in the courts, because the fear presumably will be, how can we issue guidance or develop guidelines in cooperation with the private sector where doing so may amount to an acknowledgement that there were insufficient guidelines at the time that we imposed the sanctions on the directors of La Polar. How do we risk being accused in La Polar of hindsight bias? I understand those risks. I think the risks of not working together and developing guidelines are higher. And Alfredo alluded to this in his remarks, but the risk, of course, is one of distorting the role of boards of directors. And I see this all the time in North America, where when you think about ultimately what it is that boards are supposed to do, in my view, the greatest role, value that boards can contribute are counseling, supervising the development of a corporate strategy, and then supervising the execution of that strategy. The difficulty, of course, is when you shift the balance of the focus of boards more and more towards compliance and more towards worrying about their personal liability. Regulation runs the risk of, in effect, by assuming the worst and by causing directors to assume the worst, you sacrifice the best. And the there's a huge opportunity cost in that. Remember, again, what is the corporation? The corporation is this legal construct that plays a critical role in wealth generation in market-based economies. And if we assume the worst, and if we cause directors to assume the worst, we have them working harder and harder, but not necessarily more productively, and you run the risk that they lose sight of the ultimate purpose. They shrink from risk-taking, which is what's necessary to create wealth, and we end up with a system that frustrates everyone's expectations. So, for that reason, I would urge both the super, but also the community, ICARE, the others, the Central, to collaborate now, even in the face of a difficult situation in La Polar, to develop clarity for directors moving forward.